Lewis is here.
Yeah, I see. Hey, Dennis outside, right now. Tommy? Come on, we need some help here.
Heard testimony today in the murder trial of a Port Arthur man. 23-year-old Stephen Angel is charged in the 2021 shooting death of Jacoby Rubin. Prosecutors say the two guys had an argument on social media and then agreed to meet up, where their fight was caught on video. After that brawl, they say Angel went to his car, grabbed a gun, and shot at Rubin's vehicle, eventually hitting Rubin. This is Angel's second trial after a jury back in February failed to reach a verdict.
We call 22-39014 the state of Texas versus Stephen Angel, present with his attorney and the state's attorneys. The jury has called two bells indicating they have reached a verdict in this case.
Wait outside. I'm
Yeah, I'm sorry. Something has just come up we have to take up before we bring the jury in to take this verdict. Okay, go ahead. What state say?
So Judge, I had first amendment notice back on August 6th of 2024. Given notice of intent to enhance his punishment under 1242F of the Texas Penal Code. It is my intention, if this is a guilty verdict, to read the remainder under paragraph 2 of that notice, like we would if it was a part of the indictment. And further presents that before the commission of the primary offense, the defendant was finally convicted of the felony of assault of a public servant on February 7th, 2017, it calls number 1165 in the 21st District Court of Lee County, Texas. Gives him an opportunity to enter a plea of plea or not trade.
I object that it's not part of the indictment, even in the indictment, judge. It was just given notice and that, to me, that's different. It has to be put on through evidence in reference to his prior. It's not part of the indictment that was presented to the jury, or part of this record at this point.
My response to that is an indictment is just about notice. So if we give someone the intention that if we give them notice in this written form, it's considered proper. We do it all the time.
I understand.
Actually, it was at the time, this was at the court's behest when we tried this case first time.
What's the
Oh, we never got to that.
what's the date that you're using? Because I've got
My file mark date for this notice was August 6th of 2024. That was me amending the prior notice because I think there was a mistake in the number of district.
okay. This is the first amended notice of state's intent to enhance punishment.
Correct. Judge.
You've received that. Discussed this with your client a year ago.
Yeah.
Okay, you're on notice,
On my notes.
and it's formally filed. I don't see where there is formality that needs to be made where he has to plead true or untrue. I know the way we do things on the enhancements on paragraphs that enhance subsequent paragraphs to the primary charge on indictments. But the key is given fair notice and of what the state intends to prove. And at the end of the day, he can stand by the presumption of innocence, and the law states that your burden is to prove it. Even when you plead true, when a plea of true is done, supplemental evidence is made to support the plea. But the defense acknowledges you're on notice. You've been aware of this first amended notice of the state's intent to enhance punishment with a prior felony of assault of a public servant on February 7th, 2017, and cause number 1165 in the 21st District Court of Lee County, Texas, which the state intends to present before the jury and presumably ask for enhancement of punishment. If the defendant is found guilty, punishment can be enhanced to no less than 15, nor more than 99 years confinement in prison or life in prison.
Yes, sir.
And defense acknowledges that notice of those allegations have been received, and you've discussed that with your client. Okay. Is that true, sir? All of this, you're aware that that this prior conviction can possibly be presented before the jury, which would enhance your punishment range.
Yes, sir.
And you've discussed that with your attorney.
Yes, sir.
In the event you're found guilty, it's not guilty, you're walking out of it.
Yes, sir.
Okay.
In theory,
In this area somewhere.
but he's got other pending charges.
Oh, that's right. We've got a couple of other indictments pending. But that would end this case if they're not guilty. All right, we've got a verdict. Let's bring the jury out and receive the verdict. Thank you. And thanks to the alternate jurors for holding vigil. Thank you very much. And the record shall now show that the jury is in the courtroom. Mr. Jones,
Yes,
I
sir.
believe you are the jury foreperson.
I am.
And I'm going to ask you a couple of questions. Number one, the court has received a message from the jury that the jury has reached a verdict in this case. Is that so, sir?
Yes, sir.
Is this a unanimous verdict? That is one that is agreed upon by all members of the jury?
It is.
Do any of the jurors disagree with your foreperson's representations? No disagreement. It does appear to indeed be unanimous. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause number 22-39014, the state of Texas versus Stephan Rayvon Angel, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, I have accepted your verdict finding the defendant guilty of the offense of murder as indicted in this case. And that brings us to a close of phase one of this bifurcated two-part trial. We will now proceed with the punishment phase of this trial. And once again, let me repeat, you are still under the instructions that the court has given to you up to now. Let me see lawyers, please. Thank you. Break for lunch. Can all of you return back? Is 1:30 going to be enough time? It's 1:23 now. That's a little over an hour. Is that good? Okay, thank you. And we'll wait on it. You're coming in from lunch a little tardy. That's all right. Please remember the instructions the court has given to you. We'll see you all back at 1:30. Thank you very much. Everyone else remain seated while the jury exits first. Thank you. Anything to be brought up by the parties at this time, state or defense?
Defense, yeah.
We're in recess till 1:30 on this case. David, Let's get your stuff done. Thank you. I need Brittany Armstrong. Come on up. Yeah.
That's the lowest is here.
Yeah, I see. Hey, Dennis outside, right now. Tommy? Come on, we need some help here.
Okay, we have three individuals here. As the court would place in the record, within the last hour, the court received a verdict from the jury in the case of Stephen Angel in a murder case, and the jury found the defendant guilty of the offense of murder as alleged in the indictment. So the court accepted the verdict and then broke for the lunch hour. And as participants and the jury and spectators were leaving the courtroom, this court saw some activity at the doorway, and I could see one or two bodies, and it was obvious that physical confrontation was going on at the doorway, inside the doorway and at the doorway of this courtroom, as the court was still in session on this matter. I've reviewed a video because we got videos everywhere, and I see three people flailing, punching at each other at the doorway of this courtroom and breaking some of the chairs outside, but it was a free-for-all fist fight going on. Y'all three, I recognize all three of you. This is a court of justice, a courthouse of justice, of honor. This is the last thing that should ever happen in this building, because we're trying to resolve problems in a humane and dignified and educated and advanced method. We're not cavemen, although you three acted like it, like we were back in the caves again, without any rules, without any sense of respect for each other. The proceedings moved forward in due process. The jury had their job, the attorneys had their job, and then we went through the penal code, the code of criminal procedure, and the rules of evidence to get to a disposition in this case, like we do in every case, using the rule of law, not fist fighting in front of the public. Can you imagine if this is what we did normally? We don't really need a building. We just meet and punch it out. We're not cavemen. We're supposed to be advanced thinkers, but not everybody thinks advanced thought. That's foolish. That was foolish. And I see assaults. Now, I understand that no one wants to press charges against anybody, but let me tell you this, I'm pressing the charges. You do it at the door of my courtroom while in session, you're going to get held in contempt of court. All three of you are charged with contempt of court. Carries with it up to 60 days in jail, 180 days in jail, 6 months, 6 months. And don't think I won't set an example, because this isn't going to be the kind of activity that decent, law-abiding, advanced human thought in America is supposed to be about. And it'll be made an example out of. And we got the video, and it didn't happen exactly in my presence. So it's going to be what's called constructive contempt. It still happened over this court's authority and power at the door of its courtroom while in session, which means I can't hold a hearing right now. But what I'm going to do is you're all arrested. You're going to go to jail, and we'll bring you back, and we'll have hearings on each of these cases, and I'll get to make the determination up to 6 months in the county jail. And don't you think I won't make an example? Because this isn't the kind of behavior which you can do and then walk away from it as though nothing happened. We're supposed to set examples of behavior for all of us. And some of these cases have terrible situations. I presided over the James Byrd murder cases. I was one of the prosecutors. You don't think that was hostile? Because there were a lot of folks who felt like justice needed to be served in different ways, but we did the rule of law. The rule of law worked. Those people were prosecuted and then executed for what they did. You don't think that the experience and the sacrifices that we put in to see humanitarian ways of doing justice and the rule of law and due process works? Or is there another way? No, it worked so that the people knew that this Constitution, the flag, and the rules in the Constitution are something to be honored, that we handle our problems in a disciplined, mature, advanced method so that we are the example for the rest of the world. But that's not the way that worked out there in that doorway. All y'all did was acted like the kids do at school grounds before we learned and get educated, duking it out there in front of everybody. People are here to resolve their problems in an honorable, disciplined way under the rule of law. What kind of example is that set that y'all can duke it out and just flail at each other, break things, and disrupt the proceeding? Disrupted my proceeding. I had to stop the proceedings that we were conducting here to finish this. But you got my attention, and you're gonna have hearings, each of you, and I'll get to make the decision, because you don't have a jury trial. It's in front of me. And you can be ultimately sentenced in jail up to 6 months. Does everybody understand that? All of you? Okay, I need everybody's names. Yours first, sir.
Charles Nicholas Jr.
All right, spell your first name. Is it Charles?
Yes, sir.
Your middle name, sir?
David. David
And surname, last name?
Nicholas, Nicholas.
And you, sir?
Charles Nicholas Senior.
And you, sir? Your name?
Last name Angel, first name Steron.
How do you pronounce that? How do you pronounce it? Steron? Steron?
That'll do.
Okay, what we call this is what's called constructive contempt. That means it didn't completely happen in the court's view, but it happened where it disrupted the court's lawful duties in our hearings, because it all occurred at the at this doorway. Turn your phone off, please. Thank you. It's called constructive or indirect contempt. And again, this is what's called criminal contempt rather than civil contempt, because you can be placed up to 6 months in the county jail. So all of you will be arrested. Each of you are going to be, there's a bond that I'm ordering of $1,000 in each case, for each case. I'm going to set this for a hearing in 4 to 6 weeks. And if you're unable to hire an attorney, one will be appointed to represent you. Are all of you going to be able to hire attorneys, or are you going to need appointed attorneys? Sir, you're going to hire somebody, and you, sir, Ms.
Point.
You want somebody, we're going to get you to fill something out. I need him to do an indigent form. If you're indigent or unable to hire somebody, one will be appointed immediately to help you, okay?
Y'all hold on, we're gonna take him into custody properly before he fills that out. You want to take those cuffs off.
That would be done later. Okay, I think that's, you've been given notice of what you're charged with. Assault is under section 22. A person commits an offense of assault if the person intentionally, knowingly or recklessly causes bodily injury to another, or intentionally or knowingly threatens another with imminent bodily injury, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. The offense is generally for contempt, for assault, a Class A misdemeanor, which carries with it up to 1 year in the county jail. But the court on proceeding with contempt in a contempt proceeding, again, can sentence the offenders up to 6 months, but you have an opportunity to be heard with due process and present evidence on your behalf in to answer the proceedings. And again, criminal contempt is punishable because it concerns an act which affronts the dignity and authority of the court. And the primary purpose of criminal contempt proceeding is to vindicate the public authority. And committing assaults in the doorway of a courtroom where in this courthouse where justice is the determining goal in all of our proceedings in a dignified and non-hostile way of advanced human actions and thought. That's the way we're supposed to conduct ourselves. And every case has emotional issues. We never have problems like we had just a moment ago. And that cannot be tolerated, and it will not be. It will have its punishment attached to the actions. Does everybody understand? All right, that is all. We're in recess on this. Then you are all taken into custody and $1,000 bond
Can I
is
get?
ordered.
No, we'll take care of it. We're gonna have a story on it.
Sure, yeah, talk to the bailiff and they'll work it out with you. Thank you. As before, ladies and gentlemen of the jury, the state may open and close final arguments. And what says the state of Texas?
Waive my right to open, reserve the right to close.
Mr. Burbank, on behalf of the defense, when you are ready, sir.
Yeah, police court, counselors.
Yes.
Ladies and gentlemen of the jury, you've done what I asked you to do. I may not agree with your verdict, but I respect it because that's what the system is. Okay? We didn't come to an agreement before. You have decided. Now we have to live with it. Right? So that is the way, if you do this long enough, you've done your job. And now is the time to decide in reference to punishment. And if you do this long enough, you know that there are no winners in this case, but there's arguments to be made that, and I think Mr. Ham kind of brought it up when Miss Williams was up there. He's been up there almost every week to see Stefan, and Mr. Rubin's family will never be able to talk to him again. That's a given. It would be nice if everybody could live in a world in which, as I was growing up, where there are clean sheets, food on the table, and both parents. They cared for you. They were good role models. But that's not what the world's about. And usually you don't see that when I'm standing in front of a jury, because that isn't the clients that I have. They usually have done something, they have a criminal past, and they've done something so wrong that they've hurt other people. So what do? So you look into a little bit of this in reference to Stefan, and I guess to a point, Mr. Rubin, Kobe. And you know now that they're like, oh, they're a little bit of family. They're associated as family. They're friends. We have friends. Imagine getting to a point where you go and shoot, or you do something crazy like shoot as you see in the video, and you kill your friend. Now you've decided either he's done it intentionally or knowingly. But you also have to realize that somebody, and you've heard testimony that they hung out together. They were friends and had their differences and been over each other's house. That probably wasn't intended, but his action was extremely reckless and should never have been playing with guns. But you also realize in reference to the environment, because as I asked his mom in reference to what was going on, and I think it's today's world and people that don't have a chance. No dad, prison, no support. Mom, 7 years old, family gets taken away, removed. Never made high school because he's in trouble. Chance, never. Then who knows? But I don't think he's in the same boat. I think it's a mark on society, and I think it's a lot of times it's a problem that needs to be addressed. And you're going to be able to address it now. He knows he has to be punished. But I think what makes it extremely hard is that they knew each other and they were friends. And you can take into consideration everything that was told and what you saw during the guilt innocence. And I disagree with Mr. Ham, and it is a totality of the circumstances. Yes, was not in the jury charge for the elements, but it's the totality of the circumstances for the facts and circumstances and what's going on so that you can get a total picture. And that's what I tried to convey Monday when we picked the jury. Let's put it on the table and let you all decide. But in order to do that, you have to know everything. You have to go and say, okay, why did he shoot? Was this an enemy? Was this somebody he didn't like? Did he target this person? Well, you know that by the evidence he didn't. You know by the evidence that there was a street fight. And you know by the evidence now they were good friends. And that's what's so difficult. But then you take into consideration, and I know that Jacoby's gone. And I feel sorry. I don't see mom here, but I don't know what I'd do. But you also take a look at the environment that was growing up with no education, in and out of the system. Now, I will tell you that he has a problem with incarceration and this determinate sentencing, which is a mode that in the criminal justice system, when somebody is in TYC, that's what they usually do, because they can hold them to a certain age and then they have nothing else they can do with them. So then they transfer them on. If you take a look, this was 2017 and his age, and it appears that if he got out in 2020, you only get 3 years. And so it might have been a transfer, but I will also tell you that there's a hearing in between here. And that is what to do. And so usually they get transferred and then either released or paroled, but this is for 4 years. And this was a public servant by definition, as this young lady over here testified, and was a jailer at one of the units where he was a juvenile. So I'm not here and I can't and I will not put a number of years in reference to what a value of a life is. I would hope that it is not high or in the high end, only because we now know that he was a distant family member and a friend. And we also know by the facts and circumstances this started as a fist fight and someone drew a gun out, which is all too common. I will also tell you, and you all agreed during voir dire, that this isn't the place in reference to if murder is a good law or a bad law. We're not here to judge that. That's for the legislature. But I will tell you that laws are there for a reason, and that is to protect society and to have some, I guess, law and order, and so that this doesn't happen all the time. I would ask you also, and I will tell you that in the pages that say a fine, sometimes people or jurors say, well, where does the fine go? And I will tell you that a fine does not go to the victim or the victim's family. They see nothing of a fine. It goes to the government and programs. So it's not like that person is going to get the $10,000 or the $5,000. It's going to the state. Okay. Please, again, in this totality of the circumstances, I ask you to make a decision. And go back and do your job. Or everything that you know about this, on this. He's had a past. He has a problem when he's in jail. You know that this last time is 1,300 days. So he's caged up with a bunch of people that probably have done something or similar to what he's there for. And you figure out when you put all those people together what happens. And it's not respectful. She should not have been disrespectful. I agree, just as that gentleman or whoever it was up in Lee County. Shouldn't have been. But it's the totality of the circumstances. I'm not telling you that it's right. I'm not telling you that that's something we would do. But then again, most of us had mom and dad, wasn't removed. Didn't realize that both my parents had gone to prison. because they didn't. Thank you for your time.
State of Texas.
All right, let's get some housekeeping matters out of the way. Number one, thank you. Thank you for the decision you made. Thank you for Jacoby, or as they call him, Kobe, in making the right decision. I called you team before you went by saying, all right, team, let's get to work. Let's go find them guilty and let's go from there, right? I say that because, I don't take any of this stuff lightly. I probably have said it a couple of times already. Some of y'all might have even considered it oversharing. I'm not playing around when I tell you I lose sleep at night. I must have tossed and turned all night last night. I knew what y'all were going to be looking at. I know what the hard realities are here. And in my professional opinion, the first decision that you made, it was an easy one. Not to make light of the scenario, but this next one's a little bit harder in perspective. So I said housekeeping. Number one, thank you. Number two, Mr. Burbank is absolutely correct. There is no need for a fine. Nobody benefits from that. The state of Texas does. It'll go to some ancillary fund where, all of a sudden the legislature will decide where that money goes to later. I am not asking for you to assess a fine. I make this decision every day as I've been working in this DA's office for the last, I'm right at 7.5 years. I work on trying to decide what's the right thing to do, right? We talk about what's fair. And so daily when I'm up there and I'm looking through my files, I see a lot of really violent offenses like this. I see some non-violent offenses, more property offenses. And I try to figure out what's the right thing to do. I told you all when we were visiting out here as a group that when we deal with guilt innocence, we're focused in on the event. Y'all remember? I said when we get to punishment, we open it up. We get the wider picture. And that's so that you get a chance really to know the individual that you're trying to assess what's going to happen. You learn, is this a habitual offender or is this a choir boy, to use extremes? Okay. When I'm making those decisions up there, I have the benefit of looking at somebody's criminal record. I see how many times they're arrested. I see how many times they've gone to prison. I look at all that because that tells me, do we have a chance here to rehabilitate this person? I determine whether or not that person's accepting responsibility for their actions. If somebody comes to me and say, hey, we want to work this out. We admit what happened here. We're trying to do the best we can. So then we're talking about rehabilitation. This person's showing remorse. He's accepting responsibility. Remorse, responsibility, rehabilitation. Sorry for my horrible handwriting. There's zero acceptance of responsibility for this. Why we're in trial? He's not accepting responsibility. We had to hold his feet to the fire, and you all had to get back there and do a hard job and make a decision about whether or not he committed this offense. We all know good and well, he knew exactly what happened that day. That's a zero acceptance of responsibility. That does not move us towards, hey, let's give him a break. So if we're checking off our list here, no acceptance of responsibility, well, we can't give him credit for that. Remorse. Remorse is when you say, I'm sorry. This should have never happened. I'm so sorry for the family. I'm sorry for the loss of this life. That's remorse. Did we hear that? I don't want to be a pain. But if you want to, you can go back to one of these videos I mentioned in my closing argument, where we hear his words in State 71 about what happened that day. There was no remorse. There was just what this man has always done in his life, which is try to avoid responsibility. So what's that leave him with? Is there a chance he can be rehabilitated? There's always a chance pigs could sprout wings and fly in this courtroom. I would love to believe that this young man could be rehabilitated. What screams out against that is his record. State's Exhibit 87. He's already in the juvenile system. This is one of the pages right out of it. One of the pages, and I'll help y'all out. I know you can't see it. I'm going to clue it in here in just a second. But in order to send somebody from the juvenile system over to the adult side, they had to have really messed up. We don't just do that for the average Joe. They use the terminology in here of being a habitual offender. That means they've worked with him. Look, I ain't making it up. There it is, habitual felony conduct. Can y'all read that? So we've got him assaulting this officer back on November 1st, 2016, while he was locked up, Jamie Lascano. April 21st, 2015, we have another assault on a public servant. March 17th, 2016, another assault on a public servant. That's 3. So Mr. Burbank says he's a problem in jail. Yes, that is true. He is definitely a problem in the jail. These poor public servants that are trying to help him get rehabilitated. What's he do? He attacks them in some form or fashion. That's what that means. The lady we heard from here today in your jail, right here in our county, he calls her a bitch and a whore and he spits on her. Now that's just one example. Imagine how many times that's happened before. I submit that he's not just a problem in jail. He's a problem when he gets out of jail. Remember what I elicited from his mom? He's hardly out. And what did she tell you? He got picked up for an aggravated assault on a woman that miraculously, after he gets out on bond, that those charges mysteriously get dismissed. Does that show rehabilitation? When he turns around from there, will kill us. Jacoby Rubin. Like this piece of paper. That kid over there is throwing away every opportunity he's had. Yet his lawyer stands here and suggests to you that that shooting was reckless, that he was playing with guns, and that you need to consider that they're friends. I don't know about you guys, but I don't treat my friends that way. If that was his friend, it never should happen. One thing I do agree with what Mr. Burbank says is that you should look at the totality of the circumstances. So he kills Jacoby and he unloads his gun trying to kill Charles. And Charles is running away as he's still shooting. Y'all remember that? If you don't, I ask you to do what we didn't do. I think I showed the video enough. It's there if there's a question about it. Is that the mark of someone we want to give a break to? Do we want to reward him for not having injured or killed any of the other people there that day? No. I want my county to be safe. I'm sick and tired of people going, oh, baby, that's just Port Arthur. I don't want to live in fear. I don't want to worry about whether or not I can get out there to my car after this trial is over with. I don't want any of this nonsense to continue. How do we stop it? One person, one case at a time, holding that individual responsible for what they did. He killed Jacoby Rubin. Killed him. And Jacoby did absolutely nothing to deserve it. So where's justice? I'm not going to stand here and ask you to give him a life sentence. I'm not. If you want to, I will not step on your toes. I'm going to give you my opinion about what I think it's worth. No disrespect to the family of either side, because it's hard to put a number on a lost loved one, right? It's impossible. I mean, if that's how we made the decision, then every murder case would be a life sentence, right? If you took a life, it's got to be a life sentence. And I can tell you from talking to too many families, that's what they want. That's what they want, but that's why we don't let them make that decision, right? Census man will not learn his lesson. We can't just slap him on the wrist. We can't. He's a habitual offender in the juvenile system. He just gets out and he keeps committing the offense. So what do we got to do? We got to put a sentence that sends the message that we want to keep at least Jefferson County State safe from him. I'm asking you to give him 60 years. Thank you.
Ladies and gentlemen of the jury, at this time, I've got the jury charge for you to refer to during your deliberations. I'm tendering to the bailiff. I'm asking you to please step down from the jury box, follow the bailiff into the deliberation room. We will await your verdict. And alternates, again, thank you for holding vigil outside. Thank you. We are in recess, awaiting a verdict. We now recall cause number 22-39014, the state of Texas versus Stephen Angel, who is present with his attorney and the state's attorneys. The court has received a message from the jury that the jury has reached a verdict in the punishment phase of this trial. I will ask the bailiffs to please bring forth the jury. We will accept the verdict. Thank you. And the record shall show that the jury is seated in the courtroom. Mr. Jones, as the foreperson of the jury, we have received a message on behalf of the jury from you that states that the jury has reached a verdict in this punishment phase. Is that true?
Yes, sir.
And again, I'm going to ask you, as in the guilt or innocence phase, is this verdict a unanimous one? That is one that is agreed upon by all members of the jury. We have alternates outside. We need the alternate jurors.
Alders.
Stand by. Thank you, alternates, for holding vigil. Mr. Jones, again, on behalf of the jury as foreperson, we've received a message stating that the jury has reached a verdict in this punishment phase of the trial. Is that true?
Yes.
And is this decision a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, sir.
And do any of the jurors disagree with your foreperson's representations? No disagreement. It does indeed appear to be unanimous. If you would be so kind, pass the documents to the bailiff. Mr. Jones, you may be seated. Thank you. And the court will review for proper form and publish the verdict. And the defendant shall rise. In cause number 22-39014, the state of Texas versus Stephan, Rayvon, and jail. We, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice, prison, for a term of 75 years. Signed by the foreperson. This is received. It is made a part of the record for all purposes. You may be seated. Ladies and gentlemen of the jury, including alternates, at this time, your duty as jurors is completed. At the beginning of the trial, I placed each of you under a number of instructions. At this time, I am releasing you from all these instructions previously given to you. Though one additional instruction, once you are discharged, you are released from your oath of secrecy, and you can talk about this, your deliberations and your feelings about the trial to anyone you wish. And you are also free to refuse to discuss the case in your deliberations with anyone. And you have every right to maintain your silence unless otherwise ordered to do so by the court. Once you are discharged, the attorneys we have some matters we have to deal with for a few minutes, then they will be released. And they always like to get input or feedback from jurors. If you're willing to be out there to speak with them, it helps them. It really does in their job. I know it helped me when I was trying cases. And if you care to do that, they will be outside shortly, and they'll appreciate whatever feedback and input you might give. Ladies and gentlemen, it's never supposed to be easy to make judgment decisions, and judge not lest ye be judged. Remember, we talked about that in Book of Matthew, but then that was used as the reason why we developed the beyond a reasonable doubt standard, and has been using it. We've been using it since 1770. But it is necessary when a democratic republic, self-governance like we have, we the people get to make important decisions. And in the first thing the Constitution states, we the people of the United States, in order to form a more perfect union, one, establish justice. Right out of the box, the foremost thing they were talking about is what you did, what you do by your decisions, what we do in this courtroom every day. How important is jury duty? It's the very beginning of our country, the foremost principle that makes us the lead country on this planet that all other free republics want to be like. But it's all up to us to continue the hard work, continuing doing the job that self-governance requires. I hope to have the honor to work with you in the future. Until then, May God continue to bless Jefferson County and her citizens, and you are excused. Thank you very much. Everyone remain seated while the jury exits first. And Ellie has documents for you for work or school or other purposes that you might need. And again, alternates, thank you very much for your time and attention and duty as jurors.
And so, thank you. Thank you. Thank you very much. Thank you. Thank you. Thank you. Thank you.
Jury has exited from the parties. Is there any reason why formal sentencing and the judgment being pronounced, is there any reason why that should not be performed at this time?
Not from defense, Judge.
Please stand, sir. Stephan Rayvon Angel, you came before this court and a jury, entered a plea of not guilty to the offense of murder as set out in the indictment. The evidence was submitted and the jury was charged by the court. And after deliberating, the jury returned a verdict finding you guilty of the offense of murder. Thereafter, evidence was presented in the punishment phase of this trial. The jury was charged for punishment instructions. After deliberating, they assessed your punishment at confinement in the institutional division of the Texas Department of Criminal Justice or prison for a term of 75 years. Therefore, it is the formal judgment of this court that you are guilty in cause number 22-39014, the state of Texas versus Stephan Angel, charged with murder, and that you shall be punished in accordance with the jury's verdict. Is there any legal reason on behalf of defendant why sentence should not now be pronounced?
No, Your Honor.
Finding nothing to bar pronouncement of the sentence, I now sentence you as the jury assessed to confinement in the institutional division of the Texas Department of Criminal Justice to serve a sentence term of 75 years. And it is therefore the order of this court that you, Stephan Angel, having been adjudged guilty of the offense of murder in this cause, and whose punishment has been assessed at 75 years in prison, shall be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's institutional division, or any other person legally authorized to receive such convicts, where you shall be confined for 75 years in accordance with the laws governing the Texas Department of Criminal Justice's institutional division. You are here now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. Your sentence shall commence this day. You will receive credit for all time periods of detention you have served as provided by law. Anything to add by the parties, state
No, Your Honor.
and defense?
Sycamore Meadows versus Tyrod LaFleur.
Your Honor, Attorney Alvin Silva on behalf of the plaintiff.
Good morning, Your Honor. Emily Booth for defendant.
All right, and where are we? There's a conditional order of dismissal on this case,
That's correct.
and this is satisfactory with both counsel.
It is, Your Honor.
All right, this case is conditionally dismissed. All right, thank you. Take care. Have a good weekend. Let's call the case of Red Line Apartments versus George Bennett IV.
I called the wrong name earlier. David Fanter on behalf of the plaintiff.
Your name?
George Bennett the fourth.
So this is your balance. What's your plan?
I applied for the rental assistance through the Department of Health and Human Services.
Did you provide a copy of the 539 form to the court?
The rental assistance form.
I believe so.
I know I told you at the first hearing, you said you're gonna do that.
Not sure of the name of the form I submitted, but it was the thing at the end of the packet.
Yes, he did.
Okay.
I do have the rental assistance.
All right, so the case will be adjourned for,
Yes. Well, and I don't have next week, so it's gonna be adjourned to August 1st. 2025 at 2 p.m. All right. Okay. Thank you.
all right, thanks.
It's fine. There you go. Should I?
Court calls the case of YPF 16
Okay.
LLC versus Kiera Fleming.
Good afternoon, Your Honor. David Fanti on behalf of the plaintiff.
Your name?
Kiera Fleming.
All right. Where are we on this case?
Ms. Fleming has a balance of $4,298.39. She indicates that she mailed the rental assistance form to the court on Wednesday.
She mailed it on Wednesday?
Yeah, I didn't know. I couldn't really hear you, but I thought you said mail it in, so I mailed it in.
Well, it needs to
Proof
be at
that
the court by
that I filled out an SIR with my tracking number and everything. I mean, an SER.
I don't have it. So.
Well, I sent it in.
Your Honor, I'll leave it up to the court what the court wants to do. I don't think
Yeah.
her balance is $4,298.39. She's been on rapid rehousing with SOS paying their portion. She's never made a payment to my client. And I reached out, and from what she has said, so I reached out to SOS to see if they were going to be able to help her with the balance. What she indicated to me
Anyways,
was,
can I talk? They're not going to be able to help. They're not going to be able to help with balance.
Ma'am. Let him finish and I will
He's
hear
rude. I
from
don't
you.
like.
You want to know what?
He's rude.
You don't try to overtalk me, because that will never happen.
That's fine.
Am I understood?
Yes.
You know what? I'm gonna pass the matter. You go down, check your attitude, and then I'll call your case back up. Have a seat. Have a seat.
Man, you about to piss me off. Come on.
Keep back talking. You better take that out of here. Oh, don't give me that look. Lee, get her out of my courtroom. Get her out of my courtroom. Court to pass that matter. Court does call the case of YPF 16 LLC versus Nakia Turner.
Your Honor, I'll wait for it.
That just messes up my whole day. Everybody else is gonna have a hard time with me now. You know, I was in a good mood and then it's just gonna take one person. It just takes one person and just messed up my whole attitude. You know? Nakia Turner. That's
Your Honor, I filed an administrative closing on this case. I was able to verify with her bankruptcy attorney that there is a bankruptcy in both their names.
okay.
And so I gave to.
And I will sign the order for administrative closing.
Great.
Got it. And YPF 16 versus Christina Morgan. That matter's dismissed on plaintiff's motion without. And so we only have her?
Yes.
Do I want you to go get it? Not really, but I don't want to hold up Mr. Pantera. Tell her she can come back in now. You know, people, if she don't act right, it's gonna be get bad. No, hey, I'm just telling you. I'm just giving fair warning.
Would you like your coffee, sir? So we can go get it for you
right now. No, I'm good. I don't know about the rest of you, but I'm good.
We respect you, sir.
Your Honor, if you want to pass.
I'll pass it and then. No, you know what? You keep talking, I'm gonna do something to you too. Courthouse case, so Augusta Woods versus the Geraldine Ballard.
Good afternoon. Good afternoon, Your Honor. David Santa Croce on behalf of Shelby Mink. Oh,
Okay, got it. Is she in the premises or?
so the woman's name, who I also have trouble pronouncing on the caption, is her grandmother. Miss Mink has been a resident for at least a couple of years with her young son, and the grandma passed away. I think it's pushing 2 years. Miss Mink has title in her hand. Is plaintiff here?
Well, that's what I'm.
That's Mrs. Lacy. This is the Levine lot.
Yes. Sorry, I didn't mean to wake you. No, come on up.
Good afternoon, Your Honor. Gabriel Lake, CP 79685 for the plaintiff, whomever.
We're on the Ballard matter.
Ballard, okay.
And I guess Miss Ballard, the named plaintiff, has passed away. Miss Mink is what we were talking about is her granddaughter who has been living there. And now, if I heard correctly, actually has title to the premises.
That's correct. So Miss Mink was here last week on her own. I was away.
Yes.
She secured a 1-week adjournment. Subsequently, we filed the proof of request for financial assistance. She's working with Hawk. She heard from Hawk on January 11th that she had completed everything, and then that they would be reaching out to plaintiff to get a ledger that I would also appreciate. So I filed an answer. We basically just denied the amount because we're on, DKI the amount claim due. Hawk has indicated that she qualifies and that she's very likely going to get assistance. The check wouldn't be cut to the 1st of August. But I believe she's entitled to the adjournment now because she has sought assistance, and we've provided proof of that to the court.
I will adjourn this to August 1st, my next available date, 2025 at 2 p.m. Okay.
Thank you, Your Honor.
Thank you, folks.
Thank you.
Augusta Woods versus Paul Reedy. And I've called Nella Reedy, but that is passed, I think.
I didn't do anything.
Yes, you did. How are you, Mr. Reedy?
Hanging in there.
All right.
Your Honor.
What's the balance on this?
The outstanding balance is $549.40 for past due rent, $179 in cost, total of $728.40.
I get paid on the first, Your Honor. I don't know.
What's your monthly rent?
Roughly $650.
Okay, so
I can
but
cover.
You get paid on the.
Yeah, I can cover them both on the first.
You think so?
Yeah.
Well, let me do
couple
this
days.
because I did adjourn it out to the first, but
If it's a writ or whatever, I'll get it paid. But
pardon?
if it's a writ or whatever you got to do, I'll get it paid on the first.
Okay, then I'm going to do it this way. I'm going to issue a judgment for possession, finding no tribal issue for this amount of the was it $28.40?
Yes, Your Honor.
$728.40 inclusive of cost. The writ would normally issue on the 28th. If he gets it on the first, no writ before August 4th,
Appreciate you big time.
Monday. All right.
Have a great weekend. Thank you.
All right, you too, Mr. Reed.
Thank you, Your Honor.
Thank you.
Of course, over my objection.
What?
That of course it's over my objection.
Whatever. I mean, yes, so noted. That's what I meant to say. Sometimes it comes out.
Keep me.
Arbor Meadows versus Stone Hoe.
April Lacy for Arbor Meadows, Your Honor.
Hello, who do I have here? Oh,
Ms. Stone. Kalila
Kalila, I need a last name.
Horton.
And your relation, we have to put this all on.
Casework.
Casework, her casework.
Yeah.
All right, where are we on this?
Thank you, Your Honor. We actually worked out a consent judgment where the defendant is going to pay $1,600 every month before the 5th of the month for August 1st, September 1st, October 1st, and November. That will bring her current on her rent. She'll have a credit to her account when she makes that payment in November of a few $100s probably. This is going to be waiving the 56-day rule, but it does allow her to stay in her unit and catch up on her.
Okay, so the 1,600 that she's paying is her monthly rent plus an additional amount.
That is correct.
Okay, just to make sure. And a writ would issue if a payment is failed to.
Correct.
All right. All right, ma'am, is that your understanding?
Yeah.
Okay. Do you have any questions regarding that judgment?
No, thank
No? Pardon?
No, thank you.
Okay, you don't have any questions. Okay. I will sign that judgment. I think it's favorable certainly to the defendant in this case. I will have to advise you that you have 3 business days to think about this judgment. If you think that there's some confusion on your part, some legal right you didn't assert, or some confusion, some legal right, or some other misunderstanding that you have regarding that judgment, you'd have to file a motion within those 3 business days. That doesn't mean I would grant your motion, right? But you'd have that time to think about it.
Thank you.
You're welcome. All right. Do you have the judgment prepared or?
It should be in the file. It's given to,
Who are you gonna try to blame now?
well,
No, who are you gonna try to blame? You're gonna blame somebody on my staff?
I'm just going to say that.
Okay, I have it. I will sign the judgment. All right, thank you. Thank you.
Thank you.
Is David still here? Hang on, Ms. Lacy, let me break in here. YPF 16 LLC versus Kiera Fleming. Parties have returned. Mr. Ventura, you were in the middle of your statement, sir.
Yes, her current balance is $4,123.39. Court costs of $175 for a total of $4298.39. She's been in rapid rehousing where SOS has been paying her portion and she's supposed to pay the rest. She has never made a payment. I reached out to SOS. They tried to reach out to her. And it's my understanding that the rapid rehousing ends at the end of July. So in August, she's gonna be responsible for the whole thing herself. She hasn't filed a rental assistance form. I don't think there's a tribal issue of fact. We would ask the court for a judgment.
All right, ma'am, what did you wish to say?
Anyways, like I was saying, SOS was paying my rent for 3 months without me having to pay anything. Like I told Ms. Terry through SOS that I ended up losing my job. And I wasn't able to pay nothing at the moment. And I'm just now getting a job and I wasn't able to pay nothing until today. But yeah, and I sent in my SER through the mail. I didn't know I had to come and actually bring it here. I don't have a car. So anytime I go anywhere, I have to get on a bus with my children. So I don't know if you're able to, if they bring the mail to y'all, but I definitely sent the SCR to this courtroom with the judge, with your name on it, Cedric Simpson.
Did,
But SOS doesn't stop. She said that I already filled the paperwork out yesterday when she came. They pay August, but after August, I won't be getting no more help from SOS. But I reached out to Hawk. They're able to help, and I did do an SCR with my caseworker, and I have an appointment with my caseworker on Monday for help, so I can get help with my rent. And I'm able to pay altogether $900 today, but that's all I can afford.
well, if we get to August 1st, then August rent is gonna kick in, which means you're not gonna be.
No, August rent is paid by her, by SOS.
I'm gonna let you finish because I'm not gonna be interrupted again.
I'm sorry.
So what else did you want to say?
That's all I had to say. That's what I said. It was already paid. August month is already paid. That's why she came over yesterday and I filled out the paperwork. So August month to be paid. After August, September, I won't be getting no help after August, is what I'm telling you.
If SOS pays in August what they paid in July, it would be $650 on a $1,300 apartment, which would mean she'd be responsible for the other $650.
That's not true.
But even without, let's assume that for the sake of argument that SOS is going to pay the whole thing. She still has a $4,200 balance. And I don't think there's any way that's going to be paid. And she hasn't filed the form, even though, you know, the previous person heard you just fine last week when you said, we get it here within 5 days. It wasn't here within 5 days. We'd ask for a judgment today.
I did turn it in within 5 days. You said turn it in Wednesday, which I did turn it in Wednesday. And who is he to say that I won't have all of it paid? Like, you don't know that. I didn't know I can get as much help as I did until I reached out to all these companies. And I was unemployed for a while, which I just got a job. I just started working 3 weeks ago. So this is my first check. You have to wait 2 weeks in a hole to even get your first check.
Your Honor, I'm willing to extend the judgment, normally be the 28th. If we were to extend the judgment to August 4th.
There's no tribal issue for this court in regard to this case. I'll grant a judgment for possession with the redemption amount of the $4,298.39 with a writ to issue August 4th, 2025. Thank you.
Can you tell me exactly what does that mean?
I just issued a judgment, the 429839 will need to be paid on or before August 4th of 2025. I've done it that way because if I grant an adjournment in this case, quite frankly, whatever the dispute is with the August rent would be added on to this figure, which I was trying to say earlier.
Yeah.
So it's a benefit that if you can find the funds to get this paid, you only have to pay this amount. Does not include anything for August.
Okay.
All right. So you have to the 4th to get it paid.
Yeah, but last thing I gotta say is that when I talked to my SOS worker, Ms. Terry, our agreement was for her to pay the full amount because she know I'm not gonna be able to pay the full amount. The money that I have now is going to be towards to the money I already owe. So August is already gonna be paid. Like the full amount is gonna be paid, so I won't have to worry about August.
Maybe you're not hearing me.
I'm hearing what you said.
The judgment, I'm not dealing with August.
I know that. I'm just let you know for sure that's gonna be paid. That's all. But thank you. Have a nice one.
Thank you.
Stop.
Nope, doesn't work.
Don't understand the assignment.
Real Properties versus Jason Mitchell.
So, Lord, Your Honor, I am going to be appearing on behalf of Mr. Mitchell.
See, now, let me just explain something. everybody in the courtroom has now been saved because Mr. Lloyd is a calming influence on me. I just want you all to know that. That's right.
I believe Beal's lawyer is in the building, but I don't know that the lawyer.
That was, she's from Levine's office.
Yeah, I don't know why she's.
I would ask for a default.
The lady in purple. What is she just walked out. You know,
This is something I said.
every this day was going so smoothly.
Hey, but you'll have stories to tell.
Then Dominic Hamden walked in, brought that lady, and then, yeah, I'm blaming you. Yeah.
Normal demeanor is not what I'm coding today.
Lacey?
I'm sorry, Your Honor.
This is Beal Properties versus Jason Mitchell. Mr. Lloyd will be entering an appearance on.
Your Honor, I'll let her.
Your Honor. This is the third hearing. And.
It is.
So Mr. Lloyd is going to enter an appearance. Is Mr. Lloyd up to date on the file?
No.
Pardon?
Because I think Mr. Lloyd's going to ask for an adjournment,
Okay,
and I don't want to agree to an adjournment. We're ready.
Okay. then I will overrule your objection to that adjournment. And I will adjourn this matter out. How much is owing on this?
$30,952.
How much?
$30,952. This is a commercial. Am I on the right one?
You are.
Okay, yeah. The commercial property, Your Honor.
Got it. Okay. Then, but I will grant the adjournment. I'll grant it August 1st, 2025 over plaintiff's.
Can we get escrow, Your Honor? This is the third adjournment. Well, now we're going into another month of no payment.
How much is monthly rent? What time? August 1st, 2 p.m. What is your?
Monthly rent is $5,507.
Is that a correct statement of the monthly rent? Okay. So what I will do is order escrow $5,507. I will just order it for the month of August.
Okay.
So he's to pay that August 1st. And as
Your Honor,
to the date, if
on the date, I have an appeals brief due on the 29th.
got it.
And this is a complicated enough case that I want to do it right. I intend to make them an offer that I wouldn't refuse in their hopes, in their shoes, but you never know. So I think an extra week might get us a lot closer to resolving this. So
Make sure that the escrow is paid. I don't mind putting it out to the, well, do I even have the 8th?
You do not.
Because of jury final settlement conferences, I don't have the 8th, and I'm not gonna put it out to the 15th, because then I'm going to,
even if there's escrow.
even if there's escrow. If escrow is paid, then I would behoove, and if some type of offer is made, I would behoove the parties to maybe stipulate to put it out to the 15th.
Okay.
All right?
Okay.
So if we get escrow in, there's an offer made that somebody's considering, even if ultimately you're going to reject it, I would expect the parties to conduct themselves appropriately and put it out to the 15th.
Okay.
I settle my cases.
I know you do. I know you do. That's why I'm not worried. Okay.
Thank you.
Thank you. Court does call the case of Lynn King versus Nakia McDonald. Thank you, counsel.
Thank you.
Good week. Yeah. Well, they may be able to stand it. I think they can. They'll stand it. All right.
Your Honor, this is Lincoln.
All right,
Nakaya McDonald.
all right. Take your hand back. There you go. All right. All right, where are we on this case? There was 1760 owed the last time that we were here.
Yes.
We talked about the late fee issue. Were you guys able to work something out?
She paid July rent after like several days on 11th of this month. So her balance is reduced to $865.86. That is include May, June, and July late fees and the utility.
So this amount is May, June, and July late fees?
Yes.
Okay, and go ahead, and what else?
There's a $70.86 utility, and before she set up a DTE account, so I paid for her.
$70.80?
Yeah, 86 cents.
86 cents. And then what else?
And
Anything else?
55 court fee.
For the court fee?
Yes.
All right. So if I take this 55 and if I take the $70, $55, and then the 86 cents, but if I do that, so of this 865, 86, all the rest of that are late fees.
Yes. It's on the lease. $5 per day is the lease.
Oh, I know.
Yeah.
I think. Do you have that broken down for, so how many, hang on, give me 865. Well, I can do it myself. That's okay. 125, 04. So I have $740 in late fees. So how many months is that?
That's from May. She hasn't paid late fee since.
Hold on a second. I'm trying to, I'm not asking what she didn't pay.
Okay.
I'm saying this $740 are late fees for how many months?
3 months. Actually, July,
Hold
she
on.
paid it on 11th, that's earlier. So that's only count for 10 days. In July, for July rent only.
I don't know what that meant.
Like May, she didn't pay late fee.
Hold on a second.
Okay.
So for July, her late fee was only $50.
Yes, July, there's a $50 plus 5 days. So on the lease, it says if after 5 days she didn't pay, or whoever the tenants, well, $50 initial fee, and plus 5 days times 5. So that's $75 on July before she paid. Then $50 on plus 5 days per day. June rent, that was $170. And May rent was the most.
That all sounds really nice and pretty, but listen, I'm trying to figure out that even if, give me 740 minus 75.
665.
So if I take July out of the picture.
Yeah.
And it's $75. She has paid for 2 months. You want to charge her $665 in late fees.
For the May rent.
How much is her rent?
The rent is $520 on her portion.
Right. So effectively, just bear with me here. You want to charge her about, my math is right, about a month and a quarter of what she pays for rent as late fees.
Yes, Your Honor. Yeah, because I really encourage tenants.
Hang on a second.
Yeah.
I understand you said, yes, Your Honor. Does something sound wrong to you about that? That was a question.
I calculated based on the lease,
Okay,
day by day.
I know what you did. I'll say it again. You're charging her $665 in late fee. Her rent is somewhere around, her portion is around $500.
520, yeah.
You're going to charge her for 2 months late fees that are the equivalent of a month and a quarter of her rent. Now comes my question. Does something sound wrong to you about that?
Well, I just tried my best to encourage tenants to pay on the time because it's irregular, totally out of my control.
Oh, I don't think it's out of your control.
Because I need tenants to follow the lease to pay so that I book on time. But if it's irregular, I'm totally, because her sheet has been
You
individual.
cannot, your late fees on any lease. The law is that they have to be in some way related to the cost of collecting rent. It also indicates that they cannot be liquidated damages. This sounds a whole lot more like liquidated damages than it does related to the cost of collection of rent.
I'll take your advice, Your Honor.
Oh, you don't take my advice. I don't give advice. I give orders. So I understand she may have been late. I get that. But I also understand that you would have to show me that somehow or another you spent $5 every day trying to collect her rent.
Yes.
Outside of the fact that, mind you, a portion of her rent you got already
Yes.
because you get it through the subsidy.
Yeah.
So
that's right.
So that's the other part that's silly about this. You're charging her $5 a day, but part of her rent is guaranteed to you. Oh, is it a HUD subsidy you have, ma'am? Then I think also the $5 a day per their lease is illegal. You can't charge it.
I think that's the lowest charge on the late fee, as I know, from the real estate market. I've talked to another real estate society and the society. They provided this number for me.
Okay, here's what I'm going to do, because you're not listening to me. I'm going to send you 2 out. You go out, figure out what might be a fair amount for her to pay given her circumstances and related to any effort you had to collect it. You guys come back to me with a number. If I don't like the number, I'm going to tell you what it is.
Okay.
Because it seems to me I can talk all day and night long telling you this $5 a day you can't charge. I told you that on Zoom. I'm telling you that today. I'm trying to explain to you why you can't charge it today. You're not listening to me. You're saying it's on paper. That's fine. I don't mind if the agreement between the parties is reasonable. That I don't mind assessing. But this is de facto unreasonable.
Okay, I'll take
To charge her that. And ma'am, understand something. You may want to teach everybody in the world a lesson. That's not your job to teach everybody a lesson. It's not your job to teach them to pay on time or to do whatever. Because sometimes, and I see she's got those 2 little babies there, she's running around at times to robbing Peter to pay Paul. Because that's just life sometimes, right?
Yeah, I understand.
So you can go out there. It seems the two of you can at least get along and talk.
Mhm.
Come back to me with a number. If I don't like it, I'm gonna give you my own number.
So
Because it's
that-
all just 2 months plus a little change that she was behind.
Okay. By the way, there's another portion and it's security deposit. She started from December 2024, and because I saw her little babies and in the winter, and so I accepted her to move in before the security deposit was paid. So, but it's not paid so far. For
Is
7,
that in this 865?
no, it's separate.
Well, I'm not dealing with the security deposit. Because
Okay.
you got enough problems with the illegal late fees.
Yeah, yeah, but this is also something I need to collect.
You guys go figure out, I'm not dealing with the security deposit. You guys go out.
Okay.
Figure out a reasonable amount.
Mhm.
I'll then determine if it's reasonable and I'll tell you what she's gonna pay on that. And then I'll tell you how she's gonna pay.
Okay, I got a
Give
question.
you guys time to try to work it out.
Yeah, thank you. And I have a question. When can we give you the response before next in person or online?
Oh, you just go out into those little rooms. You're gonna decide this today.
So we can turn in our result to you.
You go out there, you talk, I'll call your case back up, probably first part of the next block. Thank you.
Okay, thank you.
Your first.
Darlene Morin versus Emil Tito. Your name?
I'm Darlene Moran.
Your name?
Emil Tito.
This is a termination case.
And try to collect some rent.
Pardon?
And try to collect some rent. I had turned in the 7-day notice and then there's paperwork and.
You turned into the court. This case was filed as a termination.
Okay.
And then you filed a supplemental complaint for rent. Okay.
Yeah, I did that whole thing first. I first gave the 7-day notice. I tried to, in March, 550, April, 550, May, 550, I tried to get him to pay and I didn't file. Finally, I filed in June, 7-day, then I filed again in July, for eviction.
I have this case filed as a termination case. So,
Okay,
sir,
Yes, sir.
is there a lease?
yes,
Well, is it a month-to-month lease?
no, it was a yearly lease up until August 15th.
Of when?
2025. So he's almost up.
So on what grounds are you terminating his tenants?
Because he's not paid rent for 5 months.
Then you have to file a non-payment of rent case. He has a valid lease. There are certain rights that attach to a tenant as well as certain abilities to redeem the property if it's an issue of non-payment of rent. If it's an issue where he doesn't have a lease or has violated a lease in some other way, then fine. But this,
He keeps saying he's gonna pay the rent and hasn't.
ma'am, you can't terminate his tenancy. That's the way for that. I've got the wrong notice, wrong type of case.
Even though this is what they told me to do. is,
They who?
The legal thing out in your court.
I don't know what legal thing you're talking about.
They have it where you're supposed to file a 7-day notice. And then after that, file the 30-day eviction notice. And then after that,
I don't know who's advising you of that. I don't. I'm gonna tell you what I have in my file. I have a notice to quit for termination of tenancy. The basis for that termination is either it's some lease violation, which would be other than that or a non-payment of rent. But you can't do non-payment of rent with this type of notice. And then the complaint that I have is a complaint to terminate his tenancy with a supplemental complaint to collect money.
Yeah, that's what they gave me when
I don't know who gave you this, but I'm just telling,
Yeah.
I'm just telling you, you can't do
So
it this way.
now what do I need? Because he's not paid rent for 5 months, what do I need?
You have to first send him a valid notice for non-payment of rent.
I did.
If that's what, if it's this one that's in the file, that's not a valid one. I can look at it and tell that's not the one. It doesn't contain all of the indications of his rights.
Is it?
And by the way, and oh, by the way, this is not a case that was filed with whatever notice you're giving me. I don't know what this is. Okay, but that's not what was used to file this case. She can have that back. What? Ma'am, you can sit up here and go around in circles with me all day.
Yeah.
The notice that I have is not a notice for non-payment. He has a lease. If you wish to collect rent from him and then have him evicted from the premises, then you're gonna have to file a new case. This case only has the notice that's attached to it. And then this case isn't a non-payment case, if that's what you want. This is a termination case. The complaint is a termination complaint.
All right, so you can't terminate even for non-payment, you can't terminate. You can't. Okay.
I didn't say that. You can certainly terminate his lease for non-payment. You just have to do it in the right way. This is not the right way.
Okay.
And I do not see that there's a method by which you can correct this case because your notice is bad. The notice that's attached to the file, to this filing, is an incorrect notice so that your complaint can't even be a non-payment of rent complaint. It also, if you, the complaint that you did file, which is a termination complaint, the termination complaint, the basis for the termination is a non-payment of rent. I don't see a way in which this case can be corrected for you to permit you to proceed.
Okay.
So given that, I'm gonna also suggest to you, maybe you get an attorney before you start over on this thing to file this, or you're gonna have to file it. There's nothing that I can do.
Yeah.
So I'm going to assume that the notice that you sent, well, the notice here that you're intending to terminate, the manner in which that notice is filled out is incorrect. You failed to invoke the subject matter jurisdiction of the court. This court, lacking subject matter jurisdiction, can only do one thing but dismiss this case. This case is dismissed.
John?
Gonzalez, this is Judge Belarjan. I'm calling from the 57th District Court. We saw that you were trying to log in to the courtroom, and that you were in the courtroom, but then you disconnected. So we were trying to reach out to you so that we could connect with you via telephone. Please reconnect to the courtroom immediately and we can proceed. Mr. Gonzalez, please unmute yourself. Mr. Gonzalez, you're muted. You need to unmute yourself. There you go. All right. All right, let's go on the record in the matter of the people state of Michigan versus Fernando Gonzalez, file 221744 ST. Let's have appearances.
Good afternoon, Your Honor. John Duffield to the people of the state of Michigan.
Mr. Gonzalez, state your name, please. Mr. Gonzalez, please state your name. Mr. Gonzalez is choosing not to identify himself on the record, so we're just going to be proceeding. So I do note that Mr. Gonzalez had a motion for dismissal. I presumed he wished to verbally argue it, although I have reviewed the motion. Do you have any response to Mr. Gonzalez's motion?
Your Honor, at this point, I would ask that the motion be denied and that the proceeding and that the defense trial proceed accordingly. Thank you.
Mr. Gonzalez, do you wish to make any further statement beyond your written motion? Choosing not to respond. I have reviewed the motion and note that there's no basis in law for the motion for dismissal in this matter. All of the arguments are specious, and I will deny the motion for dismissal. Proceeding now.
I keep getting hung up on no cell service
I see
and I'm using Wi-Fi.
Mhm.
Can you hear me now?
Yes, now we can hear you. Very good. All right, state your name for the record.
My name is Fernando Gonzalez, living man.
Very good.
I'm here
And we already have
representing my
appearance of
corporate
Mr.
fiction of the
Duffield.
exact same name.
In regard to the matter for motion to dismiss,
Did you hear me,
Mr.
Your Honor?
Gonzalez.
Your Honor.
I did hear you identify yourself as Fernando Gonzalez. Thank you. Please proceed with your motion
Yes.
for dismissal.
I'm here representing my corporate fiction of the same name. And I'm here to motion.
Well, you're here
I'm
as,
here to,
no, you're here as Fernando Gonzalez. Because
Right,
if you're
but
not
I'm
here
not-
as Fernando Gonzalez, I will have to issue a bench warrant for Fernando Gonzalez.
you and I both know I'm representing my corporate fiction, the all caps
You
name.
cannot do that. You cannot represent a party other than yourself, sir.
Well, then we got a problem.
You,
under this
you,
part-
and you and
challenge jurisdiction.
you and I both know that. So
No, that's
proceeding
not
as
true.
Fernando Gonzalez,
If
do
I
you
own
wish
a
to
name-
address your motion for, do you wish
If
to
I-
address your motion for dismissal?
Yeah, I would like to challenge
Please do
jurisdiction
so.
like you didn't. I'm here by special appearance to challenge jurisdiction and motion to dismiss for lack of jurisdiction. I mean, I've all but trademarked my corporate fiction name. You know, we're going to just have to do this again in 6 months once it's trademarked.
Well, that's not true. Your motion is dismissed and denied because it is not based on any actual recognized legal basis. So in regard to the trial,
I object to that.
Okay,
I
that's
object to
fine.
that
You can
strongly.
object. And upon receipt of your judgment, you can go ahead and file an appeal on that if you so choose, but we are proceeding. Mr. Duffield.
Thank you. I would call Deputy Louise Hempston to the stand. Your Honor, would you like me to approach the podium or may I stay at the table through the duration of questioning?
You can remain at the table.
There's no copy of my.
You swear to tell the truth, the whole truth, and nothing but the truth.
That's it.
Have a seat, state your name, spell it for the record.
Louise Hempston, Hempston.
Very good. Please proceed.
Thank you. Deputy Hempston, where are you currently employed?
Allen County Sheriff's Office.
How long have you been employed at that location? With that employer?
Almost 5 years.
All right, and what are your job duties entail?
Road patrol for the Sheriff's Office.
Do you recall making a traffic stop with Mr. Fernando Gonzalez? I believe it was June of 2022.
Yes, June 26, 2020.
And do you know where this traffic stop was located?
It was on the northbound 131 on the 66 mile marker. It would have been in the Wayland Lake Township.
And what was the nature of the stop? Why did you initiate a stop?
I observed a vehicle traveling in front of me. It was going northbound. I was also going northbound. The vehicle did not have a license plate registration attached to it. I could see.
And so you initiated a traffic stop at that point?
Yes, sir.
Did you make contact with the driver of the vehicle?
Yes, sir.
Did you ask the driver for their license and registration?
Yes, I did.
Did the driver provide you such documentation?
He
I gotta
told me he didn't
object.
have those items. And that's he.
What is your objection?
He's labeling me a driver when he has no proof that I was transporting goods, services, or passengers for hire.
Your objection's overruled. Please proceed.
Thank you. Again, did he provide any the documentation that you requested?
When I asked for them, he said that he did not have them, and then he told me he wasn't driving, he was traveling.
Do you recall what type of vehicle the individual was in?
It was a silver Ford, I believe it was a Focus.
And to your knowledge, is that a motor vehicle?
Yes, sir.
Were you able to identify the driver in some capacity or in some way?
Yes, I was. There was some legal documents. The driver would not identify himself, and I attempted to look at the VIN plate on the front dashboard and the front windshield, which is obscured by some paperwork. That paperwork were legal documents and identified a person's name, and it also identified an address. I used that address and that name using mean to come up with a name and a picture that identified the same person as was driving the vehicle.
And did you, when that was pulled up in your law enforcement information network, did that include information on whether the individual had a valid driver's license?
Send operator status was denied suspended. So
did you inform the operator of the vehicle about this?
yes,
All right, and then was the individual whose name you read and who law enforcement information network provided you the information, was that individual Fernando Gonzalez?
yes,
Your Honor, does the defendant have the, at this point, I would ask if the defendant had the capability to turn on his video camera so that the witness would be able to verify whether the person present is or is not that individual?
Mr. Gonzalez, turn on your camera, please.
Is it on? Can you see me?
No, you have it turned off, actually.
Well, it says it's on my end, but I don't see myself.
But you probably,
How's that?
there you go. There you go. Yep.
If you were to see this individual again, would you be able to recognize him?
yes.
All right, do you see that, if you see that person in the courtroom or on
Can I speak
Zoom?
now?
If you were to see that person in the courtroom or on Zoom, please identify them and point out
Yes.
something that they wear.
Fernando Gonzalez on the Zoom screen.
Mr. Gonzalez, thank you for turning your camera on. If you don't wish to keep it on, that's fine. I don't have a problem with that, but I usually like to be looking at the person I'm dealing with in court, but I do need you to take your hat off because we are in court.
I'll take my hat off for $500.
Well, then you can either take your hat off or be held in contempt of court, or you can turn your camera off, one or the other.
I'll turn my camera off. I don't like being told what to do.
Okay, very good.
May the record reflect that.
He did identify, yes.
And so you said that this traffic stop occurred northbound US 131 near the 66-mile marker?
Yes, sir.
To your knowledge, is that within the borders of Allegan County
Yes, sir.
in the state of Michigan?
Yes, sir.
And US 131, is that a limited access highway?
Yes, it is.
All right, at this point, Your Honor, I would ask to move to admit the People's Marked Exhibit 1 under MCL 257.204A, given that it is a record kept by the Secretary of State in compliance with that statute and is a certified copy of such, if I may approach.
You may.
For the record, I would state that I emailed a copy of this document to the defendant at the email address I had on file approximately 25 minutes prior to the start of the trial time.
All right. Any objection to the exhibit, Mr. Gonzalez? No objection, it's admitted. Anything further?
Your Honor, I have no further questions for this witness at this point. Thank you.
Mr. Gonzalez, do you have any questions? Mr. Gonzalez appears not to have any questions. He's muted himself, so you may step down.
Sorry about that. Yeah, I do have a question.
All right.
How did we get this far without establishing jurisdiction?
This jurisdiction is established by the Michigan Constitution. And
Did you get the
this is a
paperwork that
duly
I sent?
recognized court of the state. I've already ruled on that motion, sir. If you wish to address it on appeal, you're welcome to do so. We do have a jurisdiction. Any further questions
you
of
don't
this
have jurisdiction.
witness? Of this witness, do you have any questions of the witness?
Of this witness? No, I don't think I do, other than
right,
who's
you may step
the
down.
injured party here? I mean, I would like to cross-examine the injured party, not the police officer that wrote the ticket.
Okay, very good. Anything else you'd like to present, Mr. Gonzalez?
I would like to present the documents that I emailed you earlier with.
We've already
my
established your
FOIA
motion
request.
for dismissal has been denied.
What
If
about
you
the
wish to
other
address
stuff
that on
that-
appeal, if you wish to address that on appeal, you're welcome to do so. I did receive your lien notice. I have no idea what that is supposed to mean. So anything else you'd like to present to the court?
Which question did you have on the document?
I don't have any questions on it.
Well,
It
if
is
you don't
meaningless
know
to
what
me.
that document is, then maybe we should.
Well, the document,
pause for a minute
sir,
and
the
figure it
reason,
out, because
well,
you're
I can
fishing
tell
for
you this,
jurisdiction when you don't
sir,
have any.
sir,
And
sir.
Your Honor,
The document.
we can't proceed.
Document.
We can't proceed without jurisdiction.
All right, I have an idea, sir. You don't interrupt me and I'll try not to interrupt you. So go ahead and make, if you've indicated that you didn't have any questions, and that's fine. I told you the reason that in regard to that, the notice of lien you sent, it's a meaningless document from a legal point of view. All right? Anything
Okay.
else you'd like
I
to
don't agree.
establish on the record?
Yeah, what about my
Okay,
FOIA
he has
request?
nothing further. You wish
Yes,
to
I
sum
do.
up any arguments you have?
I object.
Mr. Duffield.
You're not letting me proceed. You're not letting me defend
Sir,
myself.
you're not proceeding. You keep saying you want a motion for dismissal, but I've
I
already
didn't say that.
directed that
I mean, I
that is
said it was.
denied.
But I asked you, did you read the FOIA request that I just sent you a while back?
Sir, no, I did not read a FOIA request because I haven't received one. So I can tell you, and not only that, that would be irrelevant to this proceeding.
How would you know without reading it first?
Anything further?
How would you know without reading it first?
Because a FOIA request in regard to this matter, we are talking about a motion, a trial for driving with license suspended. Do you have anything pertinent to that in regard to this trial?
Yeah, the FOIA request that I sent you. Pretty
Okay,
much takes
anything
me out
other
of
than
your
that?
jurisdiction.
Sir, I am deeming that to be irrelevant. You can take
Without
that up on
reading it
appeal as
first?
well.
Without
You can
reading
take that
it
up on
first,
appeal
really?
as well. Well,
So
sir, we're on you don't file things a moment before a trial and then expect the court to receive it. First of all, we didn't receive it, but in any event, sir, I've already
Well, I
made my
never
ruling.
even-
Do you
I
have,
never
sir,
can-
I'm not going to argue with you. The matter is that is disposed of. You can address it on
That's
appeal.
why we're here
Anything-
today, is to argue.
Sir,
Now, listen to
sir, you can
Your
address
Honor.
it on appeal.
Your
You can
Honor.
address it on appeal, sir.
You want to get out of this so bad, you don't even want to fight with me on this, or what? You're just
I don't want to
gonna
fight
ignore
with
me?
you at all because that's nonsense. I don't want to fight with you. I have nothing against you, sir. I'm just asking you to proceed with pertinent information.
Well, how would you know if something's pertinent if you don't look
Okay,
at it?
that's enough. All right. Any arguments in summation, Mr. Duffield?
Your Honor, my office's obligation is to prove the elements of this crime, each one beyond a reasonable doubt. The elements being that first, that the defendant operated a motor vehicle, which is defined under MCL 25733 as a vehicle that is self-propelled. I believe based on the testimony that the vehicle at issue in this case meets such a definition. Second, that the defendant was the one who operated that vehicle on a highway, US 131 being a limited access freeway with a 66 mile marker. I believe
I object.
Is the only testimony in the evidence compels that conclusion. And third, that at the time that the defendants, at the time of the travel or of the driving, the defendant's operator's license was suspended or revoked. We've heard testimony from the deputy that she cross-checked using the law enforcement information network, which showed that the defendant had a suspended or revoked license. Further, we have since procured a copy of the Secretary of State certified driving record that the Secretary of State maintains by statute, which also shows that it has been suspended. So I believe we've met all of the elements of the crime beyond a reasonable doubt. And I would ask that the court find such. Thank you.
Any argument pertinent to the case, Mr. Gonzalez?
Yeah. I thought this case was squashed a long time ago, or else I would have prepared for trial, which I never even consented to last time I challenged jurisdiction. I should get more time to defend myself if this case is going to be going forward without me being able to defend myself. That's not fair. I thought this case was squashed the moment I sent that ticket back with all rights reserved.
Well, that's
With 72
nonsense,
hours.
and,
You
so that is,
there's nothing to
you've
base
known this
that on
case
other
has
than
been
your-
pending. This case has actually been pending since 2022.
That's not my fault.
Here,
I rescinded
well,
that
that is
ticket
indeed
in
your,
72
in
hours.
any
So
event,
your guys'
I do find that the people have proven their case
honoring-
beyond a reasonable doubt. Please, Ms. Card, go ahead and, well, okay, he stopped. I do find that he's guilty in this matter. Fines are $250, state costs $50, court costs $200, crime victim right fee of $75.
You don't have my consent on any of this.
And $150 in bench warrant fees.
And I want my bail back too.
That would be then a total of $725, and I'll give you 90 days to take care of that.
That's
Is there
not gonna
bond?
happen.
Is there actually bond that's been posted? We have $300 bond. We'll apply bond,
I object to that.
and we're applying it.
For a victimless crime, that's.
And remaining balance of $425 is due within 90 days. We're all set. We're going to mail out the judgment to you, sir. If you wish to appeal, you're welcome to do so.
Thanks.
Exhibit, Judge.
I'm sorry?
Exhibit.
The exhibit's returned to the prosecutor. Court's adjourned.